Rules Committee will be in order. Today we're meeting about H.R. 20, Preventing Greater Uncertainty in Labor Management Relations Act. And we, by unanimous consent, are getting started here without all of our members. The gentleman from Massachusetts indicated he's ready, and so am I, so here we go. The opportunity to be here today comes as a result of chaos that is caused by President Obama's unprecedented, unconstitutional recess appointments to the NLRB. In January of 2013, the D.C. Court of Appeals ruled that the President's 3 recess appointments to the 5-member board that were made in January 2012 were wrong and unconstitutional. However, the NLRB and the President have ignored this ruling and have chosen to literally thumb their noses at the D.C. Court of Appeals. This should not be a bipartisan issue. This should be a bipartisan issue and not a partisan issue. So I'm sure it will be then. Thank you very much. This should not be a partisan issue. This is a question of separation of powers and upholding the Constitution. And I believe whether it's this president or another president, we would want to make sure here in the House of Representatives and in the spirit of good government to make sure that we all understood the rules of appointments and the things that should take place. So we're here at the Rules Committee today to address the economic and regulatory discord caused by the President's unconstitutional appointments by allowing business to retain certainty among the regulatory avalanche that continues to stifle job creation and economic growth. So unless we act, these decisions will inject additional economic uncertainty into our already struggling economy. The NLRB continues to meet to issue consequential and controversial decisions despite having what we believe is the unnecessary quorum to do so. It is pursuing an aggressive agenda of excessive government regulation, overturning decades of established law along the way. Once again, this is an avalanche of regulatory overreach and uncertainty about its validity, and it's going to waste taxpayer dollars on costly litigation and compliance efforts, and it's causing anti-competitiveness in the marketplace. So House Republicans believe that job creation and economic growth comes from free enterprise and private investment, not through excessive government regulations. H.R. 1120 will give our nation's businesses the legal certainty that they need to know so that they can focus on expanding their companies, hiring new employees, and growing our economy, not looking at rules and regulations that are made later to be overturned by the court. So I am pleased that you are here today. Does the gentleman from Massachusetts have any opening statement? Gentleman does not. We welcome both of you today to the committee. We welcome you both back. As you know, David Dreyer, your former favorite Rules Committee chairman, has retired, and I've now taken over in January, and I'm delighted to see both of you. And as always, without objection, we'll accept any written statements that you have and know that you bring expertise to this table on this issue. We'd welcome the chairman of the committee first, Mr. Klein. Gentleman is recognized.
Thank you, Mr. Chairman. And acting ranking member, members of the committee, thank you very much for letting us be here today to talk about H.R. 1120. I believe that H.R. 1120 provides an appropriate congressional response to this ongoing chaos that the chairman described. I'd like to take advantage of the chairman's offer to have my statement submitted for the record and just make a couple of points here because the chairman covered some of the argument. The crux of the matter is that after the President made those recess appointments, challenged by many as not being valid, being unconstitutional because the Senate was in a recess, the point of this bill is that whatever you think about the constitutionality or the appropriateness of that, the court has acted. The D.C. Court of Appeals, D.C. Court, 3-judge panel, has ruled that those appointments were not constitutional, and therefore the National Labor Relations Board does not have a quorum. It, in fact, has one member, Chairman Pierce, who is constitutionally a member of the board. So we now have a situation where the board has made decisions, some 600-plus decisions that are all open to question because of the court's ruling. To complicate matters, unlike in many other cases, anybody who wants to appeal an NLRB decision can appeal it to the D.C. court, the very people who said that it's not constitutional and there is not a board. So there really is chaos out there, Mr. Chairman. Employees, employers, unions don't know what to do. And all of those groups, unions, employees, employers, are running up to this problem and starting to flood the system with appeals. So we think that it is important that we get this clear in statute. I was pleased to see that the President has made some nominations to address this problem, the lack of a quorum. But as we all know, that requires Senate confirmation. I don't know how controversial those nominees may be, but it is important that we get a constitutionally constituted NLRB as we go forward. Very briefly, what this bill does is it requires the board to cease all activity that requires a quorum of 3 members. Previous courts have ruled that you have to have 3 members in order to have a quorum. It prohibits the board from enforcing any action taken after January 2012. Restriction on the board's authority would be lifted following one of 3 events according to this bill. First, gets to the Supreme Court. The Supreme Court rules on whether or not the appointments are constitutional. Second, a board quorum is constitutionally confirmed by the Senate. Or third, these so-called recess appointees, they expire when the first session of the 113th Congress adjourns, and then there'd be no question that there would only be 1 member, and if the new members haven't been nominated and confirmed by the Senate. Some have argued, and we heard it in committee, that the bill would prevent workers from benefiting from a board decision. But this ignores the reality of the current situation. We don't have valid board decisions because the court has said we don't have a board. A board decision offers no protection under these circumstances. It's also been argued that H.R. 1120 is part of a larger effort by Republicans to dismantle the rights of workers. I've heard this a number of times. But we're here today because the President chose to take an action which was subject to question and criticism at the time he took it, and the courts have now ruled on that and put the entire marketplace, employers, employees, and unions, into uncertainty. We need to clear that up, get this board to stop acting. We've asked them to stop, and they have chosen not to. But with each decision, with each action, they add more uncertainty and add more to this churning and chaos. We need to bring a stop to it. I yield back.
Thank you very much. Mr. Andrews, welcome.
Thank you, Mr. Chairman, colleagues. I'm honored to represent Chairman Miller, Ranking Member Miller here today, who will be leading our efforts on the floor. And I thank you, Chairman, for the good humor with which you conducted proceedings here and for your friendship.
Yes, sir.
I'd like to say a few words about context. Thank you. About context and chaos. The context of this bill, I think, is striking when you consider what we're really hearing from constituents around the country. This bill is almost a metaphysical exercise about whether the board exists and what happens if it does or doesn't. But there's something happening across the country today because of the sequestration that I would venture to guess that every member of this committee has heard about. And that is that certain chemotherapy treatments given in doctors' offices are under a part of Medicare that's subject to a 2% cut. And a lot of physicians have now taken the position that they will no longer deliver that chemotherapy care in their offices until the sequestration is lifted. There are proposals, some of with which I agree and some of with which I disagree, that would end the sequestration or replace it with different sets of budget cuts. I would just respectfully submit that that's what should be on the House floor because it's an issue that thoroughly affects our constituents, but it isn't. So what we have is this bill that purports to reduce chaos. It adds to the chaos. It adds to the chaos. It is true that the D.C. Circuit has rendered a decision that says that certain decisions of the board were invalid because the D.C. Circuit believes that the recess appointments that were made to place several members on that board were illegal. The U.S. Supreme Court will either take up that case or they won't take up that case. There is a much more direct way to resolve this problem going forward, this chaos going forward. There are now 5 nominees sitting before the United States Senate, 2 Republicans, 3 Democrats, sitting before the United States Senate. And frankly, we don't want to tell our brothers and sisters on the other side of the Capitol what to do, but it would be refreshing if they actually took a vote on these nominations. I want to say for the record, it's obvious both parties in the Senate have paralyzed the nomination process in this way. This is not simply a problem created by the present Senate minority. Admittedly, both sides have used this tool. But I think it's been used to such an extreme degree in the last couple of years that the answer here is pretty obvious. Put the 5 nominees up for a vote and see if they get confirmed or not. If they can get confirmed, the chaos is over going forward with respect to the decisions that have already been rendered. The U.S. Supreme Court is likely to resolve those. So, with all due respect, this bill, I think, is at best irrelevant to solving the problem, and at worst, exacerbates the problem. Here's how it exacerbates the problem. The way the bill is drafted, that a person whose rights have been violated, whether it's an employer or an employee under the National Labor Relations Act, has no remedy. So a person who distributes leaflets in the parking lot at work and says, I think we should form a union, I think that we should organize and bargain collectively. The next day she's fired. And there's a finding at the regional level of the NLRB that that's a violation of her rights. No one is in a position to enforce her rights. She loses her job, she loses her paycheck, and she loses any right to have this enforced by a court of law. Shoe could be on the other foot. Let's say you have a situation where an employer believes that an unfair labor practice has been committed by the union. The employer pursues this, and the regional office determines that there has been, in fact, a violation. No one can enforce that order on behalf of the employer. To further complicate the chaos, there are 11 regional directors who were appointed since January of 2012, which is the sort of acid date, the litmus test date in this bill. As I read this bill, those 11 regional appointments are invalid, which means that everything those regional directors have done is invalid, which means they can't act anymore, which means citizens of our country, constituents of the ladies and gentlemen in this room, who are unfortunate enough to live in one of those 11 districts, effectively have had the National Labor Relations Act repealed in the places in which they live. You want to talk about legal questions? That might be an equal protection law question. That someone who happens to live in a district that has a validly appointed regional director can pursue their rights, but someone who doesn't can't. This is a chaotic situation, no question about that. This bill makes it worse. The solution to the chaos is for the United States Senate to do its job and cast a vote on these 5 nominees. The solution to the chaos is most certainly not to compound the chaos by this provision that would jeopardize rulings that have already been made and that would shut down 11 regional offices. I frankly believe that the underlying issue here is collective bargaining, and if you believe in collective bargaining, you wouldn't support such a bill. If you are bothered by collective bargaining, you'd support such a bill and paralyze the NLRB. We should not do that. And we would urge that the bill be defeated. Frankly, we did not offer amendments, Mr. Chairman, in committee. We're not prepared to offer any here either because we think the bill is so fundamentally flawed it cannot be repaired. Thank you.
I appreciate the gentleman, and part of his comments at the very end, in fact, were true. We received, I believe, 2 amendments that were placed before the committee, and none were or would be within the rules of the House.
Yeah, I would also say, Mr. Chairman, I don't know the merits of those amendments, but the committee Democrats have not put any amendments forward.
So,
thank you.
So in fact, I'm trying to suggest that you're right. We were not finding that this was a item that was heavily popular with those who chose to come participate on the amendment process. Thank you very much. I'm delighted that both of you are here, obviously representing the Ed and Workforce Committee, and feel like that you represented not only your chairman well, but delighted to see you as well, Rob. Gentlewoman from North Carolina is recognized.
Thank you, Mr. Chairman, and I thank my two colleagues from the Ed and Workforce Committee for being here. I would just make a brief comment. Mr. Andrews, you talk about what the remedy is for this, but the remedy would have been for the President not to have violated the Constitution. And we're here cleaning up that mess, basically, that was created by the President's action. Now saying the Senate can solve this problem, certainly the Senate can, but we don't have control over the President. We don't have control over the Senate. We need to do in the House what we are able to do to try to solve problems, and that's what this majority has continued to do, and to just push the responsibility off to other people is not something that we should be doing. We should do whatever we can to solve the problems that face this country, and that's what we have been doing. The sequester was not our idea. It was the President's idea. So problems that have been caused there that you bring up that we should be dealing with, again, I think should be dealt with there. But I appreciate Dr. Rowe introducing the bill and the committee passing it, and look forward to our having the bill on the floor. Thank you, Mr. Chairman.
Thank you very much. Mrs. Slaughter.
Thank you, Mr. Chairman. I realize this is going to pass and something will happen. I appreciate both of you being here because I like the two of you. But what we just went through today already on the floor should have been enough to say, as they used to say in Kentucky, to gag a maggot. We're going to be doing this yet again and again tomorrow. I think somebody should rewrite the history of what's going on here. But anyway, back to the matter at hand. I just needed on the record that President Reagan made 240 appointments just like these over the course of his presidency. George W. Bush made 171, and George H.W. Bush made 74. Obama has made 32. And so I'm not going to ask the question because what for, but I think I do really make the statement that obviously this president is different, isn't he? And so that's where we are. I appreciate what you had said about the chaos this is going to cause countrywide. It's not just what's going to happen here. And I'm concerned about the miners case because born in Kentucky, that now it's going to be found null and void again. So I'm sure that we will go on with the dance, but I did want to put those on the record. Thank you very much, Mr. Chairman.
Thank you very much. And I would, just as an inquisitive mind, would ask, were they the same type of recess appointment where they served till the end of the term began and then they stepped down, or did they continue on?
The recess appointment is a constitutional act, and I'm assuming that all of those presidents, as well as this one, conform to the constitutionality of it.
Mr. Chairman,
You can address that issue?
Sure.
Gentleman recognized.
There are two kinds of recess appointments. There are inter-session recess appointments between sessions of a given Congress.
Right.
And there are intra-session recess appointments which take place during a recess within a given session of Congress. The appointments that Ms. Slaughter referred to were, in fact, intra-session recess appointments. There is a dispute. There is a dispute here as to whether they're exactly the same fact pattern. My friends on the other side point out that the Senate was technically not in recess, and that this is the crux of the dispute, frankly, before the court. We would argue that where the sole or primary purpose of a Senate session is to avoid the President's appointments power, that's not a session for purposes of the Constitution. That's one of the issues being litigated. But President Bush, the President W. Bush, did in fact make the last four appointments to the National Labor Relations Board by an intra-session recess. So the people who were appointed by the immediate predecessor, President Obama, did the same thing.
So I'm not a constitutional expert, but I have studied as things might come. And in fact, I do believe that the President is entitled, for purposes of running the government, doing these things, to make these appointments. I believe that the correctness of the court recognized the fine points that the President and the Senate recognized at the time, and that was about their advice to the President about what they were in. And I believe it was up to the Senate by a joint agreement of how they would notify the President of what they were doing, and I believe that that became the crux
If
of
I
the
could just
matter.
be clear about that, too, then I want to be fair-minded about this, that it was our side that invented the sort of fake Senate session when President George W. Bush was in office. And they pretty much explicitly said the reason they were staying in session was to prevent him from making appointments. I think that was wrong. And I think
It may be
it's
wrong,
equally-
but
I
it
think it's equally
established
wrong,
some
yeah.
bit of precedent.
Well, but that's a precedent that President Bush took advantage of, and now President Obama is. So I think this is a very metaphysical debate.
Well, I think what I'm here today is not over politics, but under rule of law, that the Court of Appeals has ruled on this. Right. And I'm not a lawyer, I know many judges, and they decide off facts of the case and the constitutionality, which is what the D.C. Court is there to do as an arbiter for the entire country, and in this case, the point for these sorts of issues. Gentlemen, Mr. Chairman.
Mr. Chairman, I think you just made the point I was going to make. There is a lot of discussion back and forth about which presidents made which recess appointments, and was it intra-session or intercession. I believe that because the Senate was in pro forma session, it was clear to me that the Senate was in session, and so these were not constitutional. Frankly, that's an interesting argument, an interesting debate, and it'll take lots of lawyers and judges to figure that out. The reason we're here is the D.C. Court has ruled and said they're not constitutional. And therefore, all these 600 decisions and the more coming, and the relief that my friend and colleague Mr. Andrews is talking about for employers and employees doesn't exist. We need to get a constitutionally constituted, I'm going to practice saying that, constitutionally constituted board. Now, my friend Mr. Andrews said, well, the Senate can just fix this by confirming the President's nominees. This is a give and take. It's not their job just to confirm. It's to advise and to have a discussion, and perhaps the President may want to consider making some other nominees that can get confirmed. But that's what we need to do, and I'll just sort of close this part of the discussion by quoting Richard Trumka, somebody I don't quote a lot, but he said yesterday in talking about the President's nominees and the appointment, he said, talking about the system of labor management relations, which has been in disarray since the D.C. Circuit's decision in the Noel Canning case. That's what we're talking about, the disarray since the Noel Canning case. That's the D.C. Circuit. That's what we're trying to address. I believe that we need to pass this bill on the floor of the House, to urge the Senate to work with the President. If they'll pass this, then that will put even more pressure on the President and the Senate to get a board that is constitutionally configured. I yield back.
Thank you very much. Chairman Cole.
Thank you, Mr. Chairman. I'm not a lawyer, obviously, and don't pretend to understand all the legal fine points here. The discussion about, which president did what when, seems to me that's almost irrelevant once you have a court decision here. And so the question I would put to both of you, I mean, the reason to me to sort of suspend things until you actually have something we all agree aren't all the cases have already been heard and, quote, decided, now question. And clearly the losing party is almost certainly going to use that to go to court to reopen the challenge. If we had 500 or 600 of these things, why in the world would we want to have more of them? Shouldn't we just, again, try to do what we can to encourage the President and the Senate to work out their differences, but in the meantime, not create more litigation in this situation?
Well, I would say, Mr. Cole, that this bill creates a strong incentive to ignore the President's nominees in the Senate. Because what it says is that this freeze on the actions of the board goes either until the Noel Canning decision is overturned, or until the end of this session of Congress, or until the Senate confirms a quorum of nominees. It basically says, it almost codifies and rewards the behavior of not taking votes. I think Senator McCain put this very well over the weekend in a very different context about gun safety, when he said, what are we afraid of? Speaking to his fellow Republican senators, and said, we are paid to take votes, to take a position. If we disagree with a proposition, we should vote against it. If we're for it, we should be for it. And in the context of talking about the possibility of filibustering the gun legislation, he said the Senate should do its job and vote. I think that same admonition applies here. Senators should vote on these nominations.
If I may, we obviously have a disagreement there. I think this nomination, confirmation, advise, and consent process requires a discussion and back and forth between the nominator, the President, and those confirming the Senate. So I think that process needs to go forward to get a board that everybody can have confidence in. Right now, nobody has confidence in it. So you have unions whose appeals have been held in abeyance by the court because of this decision. You have employers, you have employees, and all these decisions going back to January of 2012, the 600, are now all open to question. So all of these people, employees, employers, and unions, don't know where they stand. And I think it's folly for this one-man board, or the three people, if you accept the non-recess, recess appointments, what the court has said not, for them to keep going and adding to those decisions. It seems that clear-cut to me. As Mrs. Fox said, we need to do what we can do in the House. I think it's important to pass this legislation and to put as much pressure as we can on the Senate and the White House to resolve this issue.
Well, just closing comment quickly. I actually agree very much with my friend from New Jersey that the Senate ought to be voting on these things. I agree. Look, we are paid to vote. At least on this side of the rotunda, we're paid to vote. I'm not exactly sure they're paid to vote on the other side. They seem to have a hard time doing it no matter who's running the institution, which party. But in this case, until we actually have a board that we all can agree, and the courts will certify as constitutionally constituted, then it's I fail to see why we would want to create more facts on the ground that are going to lead to ever more litigation. And that's clearly what's going to happen until this thing gets settled. So why not stop this process, figure this out, encourage them, as I think this bill does, encourage the President and the Senate to work together to put this board back together, but not create more litigation in the meantime. Yield back.
Mr. Montgomery.
Yeah, thank you, Mr. Chairman. I want to associate myself with the comments of the gentleman from New Jersey. I think this bill will gut labor law and destabilize employer-employee relations. I don't think it's good no matter how you look at it. I agree with him. I don't think it's worth trying to amend this bill. I don't think it's fixable. I think there are other ways to do it. But I also want to agree with him on another point that he brought up in the very beginning, which is that we ought to be dealing with finding a way to get out of sequestration at this particular point. I read that article, too, that the gentleman refers to about how people's cancer treatments are being complicated because of the cuts as a result of sequestration. And I want to, Dr. Fox said this is the President's idea. Well, I want to kind of, I feel like compelled to say, to put an end to that fiction, that this was some other President's idea. But I do agree with her on one thing when she said that we can't control the Senate, we can't control the White House, we can control us here in this body. And it was this body that voted for sequestration. It was this body. It was people, I didn't vote for it, but there are people on this, behind this table here who voted for it. They're responsible for this. And, you're talking about the Senate gets paid to vote. We get paid to vote, too. We ought to be voting on an alternative sequestration. And we've been denied that opportunity and time again. I just think with this, with the terrible impacts of these cuts going into effect, which I think are going to undermine economic recovery, there ought to be a sense of urgency in this place to deal with it, and there's not, and I regret that very much. So, this is what it is, and we'll vote on it tomorrow. But I wish we were spending our time trying to figure out how to help the economy and how to deal with the terrible impacts of sequestration. I yield back.
Thank you very much. Appreciate the gentleman. Mr. Woodall.
Thank you, Mr. Chairman. I hadn't planned on speaking on this bill. I thought it was a fairly straightforward bill. I saw the notice go out that anyone who could file amendments here at the Rules Committee, and only 2 amendments came in. I think it's just critically important that this get done. And I just couldn't disagree with the gentleman from New Jersey more. I heard the gentleman from Massachusetts and the gentleman from New Jersey say, "Oh, there's so many other ways we can deal with this uncertainty." I don't know what they are. Maybe, Mr. Chairman, you all have seen some other options. We have a board that is responsible for protecting the rights of workers in every single one of our districts. A board that was constituted in a way that the president knew wasn't going to fly. As the gentleman from New Jersey accurately pointed out, because of a process crafted by Democrats in the Senate last session that effectively prevented President Bush from making any appointments, that same session, that same technique still in practice today. President knew it wasn't going to fly, did it anyway, was not only rebuked by the court for doing that, but in so doing has now opened up a century worth of recess appointments and the way that presidents and Congresses have acted. And we have an opportunity now to at least stop the bleeding. Gentleman from New Jersey is absolutely right. The folks have no protections today because there is nowhere to go. And to continue to have an illegally constituted board offers folks no protection. To recognize the failure of what has happened and encourage the Senate to get to work, to get about their business, and to protect the rights of workers in my district. And Mr. Chairman, I'm just so pleased that you all have moved this forward. I am frustrated that we can't do more in this House.
Mr. Chairman.
Dr. Fox is exactly right. We can only control what we do here. But this is every day that we allow what we know to be an unconstitutionally constituted board to continue making decisions that affect not some metaphysical outcome out there, but the real lives of folks in my district every day. It is unconscionable to allow that cloud to continue to sit over this.
Well, gentlemen, yield.
And since we cannot vote on confirming nominees, the best that we can do is to make it clear to the Senate that we will not allow this unconstitutional process to continue. We will not allow folks in our district to be shut out of the process altogether, and we will, as a gentleman to my right already said, agrees that we would encourage the Senate to get about the business of voting. I'd be happy to yield to my friend.
I thank my friend. Knowing of your sincere concern about this, and I share it, are you prepared to join with me in calling upon the Senate to take a vote on these 5 nominees?
Not knowing what we're calling a Republican nominee on that side of the aisle, to the degree that my friend from Kentucky has selected those folks, has in counsel with the president said, these are folks that I trust. I trust the gentleman from Kentucky to make those determinations. So absolutely, every single nominee that my friend from Kentucky has had a voice in selecting, I think should be voted on tomorrow. And I would, not only would I join the gentleman, I would say we ought to get about that business right now.
That's a novel constitutional interpretation. I don't think Mr. McConnell got any electoral votes in the last election, so he's not really entitled to make appointments. I do think there ought to be consultation. But can I just say this? If the minority leader in the Senate or any other member of the other body is discomforted by a nominee, they should vote no. The issue is not whether the minority senators have to vote for these nominees. The issue is whether the Senate is properly discharging its constitutional duty to take votes in the first place. So is the gentleman prepared to join me in calling for the Senate to take a simple up-down vote on these 5 nominees?
I would say to my friend, as he fully knows, the question at the heart of this case is the erosion of legislative, constitutionally delineated legislative power that the executive has usurped one bit at the time, 1 year at the time, 1 decade at the time on both sides of the aisle. And so I would say to my friend, absolutely not am I prepared to join with him and be complicit in delegating more legislative authority to the executive branch. Absolutely not. What we're going to find when the court takes up the case, as the gentleman absolutely accurately suggests that they will, is that it's not just a 72-hour recess that isn't a recess, but the intra-session recess doesn't exist, period. This is the recess appointment was designed so that the country could operate, not so that the executive could have his or her way.
Yeah.
So that the country could operate.
On this, that I think his position is a little internally contradictory, that the way for the legislative branch to stop the erosion of the authority of the legislative branch is not to vote on anything. It seems to me that that kind of passivity would embolden any executive to do more at the expense of the legislative branch. That all we're simply saying here is that, as Senator McCain, I think, said very well last weekend, legislators get paid to take votes. So take votes. There's 5 nominees here. If a majority of the Senate believes they're inappropriate nominees, they won't be confirmed.
It is.
I think that's what they should do.
I would say to my friend, knowing of his sincere desire to help working men and women in his district, the frustrating part of this for me is everyone here has lots of great advice about what the Senate ought to be doing. Just great advice. And yet, in doing nothing here, we are complicit in allowing one reversible decision after another, after another, after another to stack up every single day. The Senate ought to be doing better. And you and I should be able to join together and encourage them to do better. But while we're waiting on them, which seems to be the general theme of what goes on here in the U.S. House of Representatives, we have to do what we can.
Yeah.
And the truth is, I come from a right-to-work state. And as long as the NLRB decisions continue to be guaranteed to be tossed out and made irrelevant one day at the time, truth is, Georgia's not going to be as heavily impacted as New Jersey is. Truth is, we're probably going to be okay. This unconstitutional activity can continue to go on day after day until the Supreme Court gets around to hearing it, striking it all down. We're going to make it out okay. But there are a lot of constituencies who aren't. And it's not about it's not about what we did to get us in this mess. And what we did was, again, allow executive power to erode the power of the legislature year after year after year. But it's about what we're going to do now. And I would say to the gentleman, if the gentleman is comfortable that these 600+ decisions that the court has, the appellate court has decided have absolutely no force of law, made by folks who had absolutely no ability to make decisions because they were unconstitutionally appointed. What is the gentleman's solution? Because, again, I would want to encourage my chairman to get about the business of solving it. I think he found the right solution here, but if there's a different right solution, I'd just be interested in knowing what it is. I would welcome the gentleman.
The gentleman's continues to say that it's clearly unconstitutional, these appointments. That's not correct. The D.C. Circuit has concluded that is the case. They, of course, are not the final authority in the interpretation of our law. The case is up on a writ of certiorari that the United States Supreme Court will either decide to hear this case or not. The gentleman's correct. If the court denies cert, then the decision of the D.C. Circuit stands, and that's the law. But it is not correct to say that this is settled law. If the United States Supreme Court opts to take this case, then they will be, as they say, they are not final because they are right because they are final. There has not been a final adjudication of this case.
I would say to my friend, who is a much more accomplished attorney than I am, that this was a decision not made by the appellate court. This was a decision known in the hearts and minds of all Americans on the day the president made these appointments. What my friend from New York said earlier was absolutely false. We have not had one single president make this kind of 72-hour wearing session appointment.
If the gentleman will yield.
I would ask my friend, because again, he is much more accomplished than I am,
to take the position.
To tell me what about, because you've seen these numbers, and as you accurately recognize, in the last years of the Bush administration, in an effort to prevent appointments from occurring, the majority leader, Harry Reid at the time, still today, looked at the Constitution, realized the president couldn't make appointments if the Senate was in session, and decided to keep the Senate in session. After making that decision, how many more recess appointments did President Bush make? I think my friend from New York had a number well into the triple digits of similar appointments that President Bush had made. How many did he make after that process began?
I don't know, but I want to say.
Conveniently, I do know, and the answer is 0. No, the answer is zero.
A little different.
The answer is zero. And I say that, no, because this is...
Mr. Chairman.
If what we want to talk about...
Mr. Chairman, just with respect, I mean, there ought to be...
Gentlemen,
Right.
hold on just a moment, please. Just a moment, please. Do you have a point of parliamentary inquiry?
The point of parliamentary inquiry is, does the witness get to answer any of the questions, or is he just going to be shouted at during the entire hearing?
Well,
And I think out of
first of all-
courtesy, we ought to have a give and take here.
I think that was a good question. I don't know if that was a point of parliamentary inquiry, but what I would say is the chairman is interested in the person that is asking the questions from the committee to be able to direct during the period of time that he chooses to make a statement or ask questions. And the chairman will make sure that both the witnesses who are before the committee will have time to respond if they'd like to take notes, but we will make sure before we go to the next person on the committee, the person that controls the time at this point is the gentleman from Georgia who is on the committee, and he is asking the questions, and he is making the statements as he chooses. And so we would ask both of you as witnesses to abide by this understanding.
Yes, sir.
Gentleman's recognized.
I thank the chairman. I'd say to my friend from Massachusetts, there are very few folks in this House that I enjoy learning from more than I enjoy learning from the gentleman from New Jersey. So I would hope the gentleman from New Jersey does not share your concern that he doesn't get a chance to engage in that debate. But the answer being zero, that we have not had this circumstance happen. 2 years and 2 months I've had a voting card here. Longer than that, I've watched this process. I guess it's just disappointing to me that we couldn't find that mechanism. Candidly, Mr. Chairman, I thought this was it. I thought this was the bill that folks were going to come together around and say, we need answers for workers in our district. We need answers for employers in our district. We need certainty for those folks. I thought it was going to be this bill. But for us to perpetuate the fiction that there's not a problem here and that business as usual tomorrow protects the rights of workers, I just think we're better than that. Because you and I both know business as usual, if it goes on again tomorrow, the rights of workers are not going to be protected. Nor will they be the next day, nor the next day, nor the next day. It is incumbent upon us to rise to that. And to suggest anything different, I think, again, sells us and our duty to our constituents short of what we could be. And I'd be happy to yield to the gentleman.
I would simply say, in response to my friend's questions, that business as usual is going on. The President is making nominations. The Senate is ignoring those nominations and paralyzing the board. I won't ascribe the motives, but that's the reality of what is happening. As far as perpetuating a fiction is concerned, the gentleman, my friend, said that everyone in the country knew in their hearts and minds that these decisions, these appointments were wrong. With all due respect, there's a significant body of legal opinion on the other side of that question. There's a significant opinion from the White House counsel's office that says that these decisions were, in fact, constitutional. Now, reasonable people can disagree on those conclusions, but certainly my friend is overstating the case when he says that everyone knew that this was an incorrect constitutional interpretation. The truth is that there are at least two sets of interpretations. The D.C. Circuit chose the one that my friend evidently agrees with, but the rest of us disagree with it, which is why we have an appellate process, which is why the United States Supreme Court will, I think, grant certiorari in this case, and the result will be resolved the way it is under Marbury versus Madison.
And sadly, in this body, we don't have as many opportunities to work together as I hoped that we would, nor does the Supreme Court. And I would tell the gentleman I look forward to sharing a Coca-Cola with him after the court grants that cert and makes that decision, because much like we had a unanimous circuit court decision, our Supreme Court is going to be together on this issue in ways they very rarely get to be, because while the gentleman did cite the three people in America who disagree on this issue, there is going to be a substantial body of justices.
And I would simply say this to you, that your state makes Coca-Cola, ours makes Budweiser. So if we win the case, we're going to have a much better time than you will.
I yield back, Mr. Chairman.
Thank you very much. And with respect to the intercede the discussion that took place. Both of you are senior members of this body, and you come up here with great hopes and expectation, and we accept you that way, and your humor and your dialogue is important, and I appreciate you in that process. Mr. Polis.
Thank you, Mr. Chairman. Without objection, I'd like to submit the statement of administrative policy to the record.
Without objection.
Thank you. And I appreciate Mr. Woodall's acknowledgement of Mr. Andrews as a much more accomplished attorney, in fact, a former law professor.
I don't agree with his interpretation of that, by the way.
Out of humility, no doubt.
No.
And as such, I'm, of course, inclined to follow the legal analysis of Mr. Andrews. However, I myself am not an attorney, and I try to evaluate these matters on the merits of the policy. Let the courts be the courts, and let the legislature be the legislature. With regard to part of the discussion between Mr. Woodall and Mr. Andrews, I think clearly on any issue, in the failure of the legislature to act, the executive takes more prerogative. We see this in immigration. Congress has failed to act thus far. The president issued deferred action orders that have enabled hundreds of thousands of young people to work and go to college. I hope that Congress takes up immigration reform. Hashtag time is now. There's tens of thousands of people outside calling for that today, and there's a bipartisan plan that's expected shortly. Likewise, with regard to ESCA reauthorization, a subject near and dear to both my heart as well as the hearts of the chairman and Mr. Andrews here as well, in the absence of legislative action, the president, through the waiver program, has effectively taken on more authority. Now, again, none of us want to advance bad legislative action, and I would argue that the bill that emerged from the Senate Help Committee last session was, in fact, a step backward rather than a step forward. But clearly, in the absence of ESCA reauthorization, it is the president's prerogative to try to do what he can with the muddle of laws that he has on the books to enforce, and I think he's done so in good faith and generally with support from senior education leaders in both parties to the extent he can, absent a reauthorization. So again, here we are trying to evaluate on the merits what we should do with regard to appointments to the National Labor Relations Board. And my question for Mr. Andrews, in examining this on the merits, we've discussed workers' rights, and that's something that I is near and dear to my heart. But in addition, I, like many others on this panel, consider myself pro-business and pro-job growth. And I'd like to ask Mr. Andrews the uncertainty that this direction would set on American businesses in terms of not being able to have responses on issues that are critical to their growth, retroactively as well for American businesses, both in terms of decisions that have gone their way, as well as differences that have been negotiated along the way prior to reaching final resolution through the National Labor Relations Board, in a large part because that loomed as a final resolution. So what kind of harm to American businesses, in your mind, would this potential route of enshrining in statute a intermediate court decision cause to American businesses and job growth?
One very significant problem is that most of the work under the National Labor Relations Act is done by the regional directors at the regional level. Most labor cases are settled like most cases in American law are settled. Because this bill goes back to January of 2012 and apparently invalidates the appointment of 11 regional directors, entrepreneurs, employees, unions in those 11 districts, I think arguably would be approaching a regional office that has no authority to do anything. So it's entirely conceivable that a settlement negotiated under the auspices of a regional office would be invalid. It's entirely conceivable the office could take the position that they couldn't do anything to help resolve that matter. So let's take an employer who is unfairly accused of union busting, and the employer wants to go get some relief. And the matter winds up before the regional director, and the regional director says, well, I really can't help you because I wasn't validly appointed. Nothing that my subordinates do is valid. Or a union organizer, an employee who tries to form a union, is discharged, punished, fired, in some way some way reprimanded for what has happened.
And just reclaiming my time for a moment, so this uncertainty, this regulatory uncertainty would hang over a business, potentially hurting their valuation in the public marketplace, hurting their share price, knowing that there was no way, no process whereby they could seek redress for being unjustly accused of
because the non-adjudicatory, more conciliatory negotiation-type actions of the regional offices are legally suspect if this bill passes. So remember, most of the work the NLRB does is at the regional level through its regional directors, and it's not adjudicated. But if 11 of those regional directors, if their appointments are invalid, which under this bill they would be, I think, we then have a problem. So I believe that my friend is correct, the chairman is correct, when he says that we'd all be better off if the decisions that are turned in jeopardy by Noel Canning are settled one way or the other. I think this simply creates more of that problem by paralyzing these 11 regional offices. And also, there's another category of this, Mr. Policy, you have to take a look at. If there are matters presently before the courts that are enforcement matters, whether they're in favor of the employer or the employee, it's not at all clear that the board has any authority to appear before the court and have the court do anything. So let's say that the appellate court says that we want to settle this matter between an employer and a union or between an employee and an employer. As I read the bill, the National Labor Relations Board would have no authority to go before the court, enter an appearance, and take a position on this. So the sincere purpose of this bill is to reduce uncertainty. But I believe the practical effect of this bill is to increase uncertainty. And the best way to end that uncertainty is for the United States Senate to do its job, call the roll, cast a vote, and confirm 5 people to serve on this board.
Thank you. And again, many members of this panel on both sides of the aisle have expressed frustration at the pace of the Senate in pursuing their constitutional duties with regard to this matter. And again, I would just, again, turning the question over to legislative prerogative and in the absence of legislative action ceding power to the executive, I just want to ask the chairman about plans for ESEA reauthorization. And again, whether this body plans to continue to delegate more and more power to President Obama over public education, or whether we plan to take up ESEA reauthorization in a bipartisan way.
Thank you for the question. I don't feel we're delegating any new authority to the President of the United States. He's taken some authority, which I believe he doesn't have legally in issuing his conditional temporary waivers. But to the heart of the question, we intend to move soon, read weeks, not months and years, to bring the bill back through committee, and I trust to the floor.
I thank the chairman, and again, I think it's understandable in the absence of legislative action on immigration, on education, on any issue, a president of either party will attempt to take action, and in fact the courts may rein in that president, they may not. It depends on exactly how they exercise that. I think it's, again, it's perfectly understandable that that would be the role of an executive, to try to make the laws work as best they can, even laws that don't meet the needs of the real world, for instance, our immigration laws. And many would acknowledge, I think most folks included our education laws, including some of the flaws in No Child Left Behind, which people of good faith of both parties agree could be very, simply addressed to make that a more workable law. So I look forward to working with the chair as well as Mr. Andrews on the ESEA reauthorization. I appreciate the legal scholarship of Mr. Andrews on this issue. And again, on the merits, I hope that we don't create more uncertainty for American businesses and American workers. And I'll yield back.
Thank you very much.
Mr. Chairman, yes, could I address the issue of the regional directors and some of the uncertainty that my friend and colleague, Mr. Andrews, brought up? Thank you, Mr. Chairman. I'm just looking at a note here to the issue of the regional directors. The General Counsel of the NRB can appoint an acting regional director to allow this to go forward. But the truth of the matter is that because the constitutionality of the board is more than in question, because we do have a court that has said they're not constitutional, there is no relief. There is no place where an employee, an employer, or a union can go and get relief. One of the reasons, I mentioned it earlier, but I think it's important to underscore it, every single case can be appealed to the same court, to the D.C. court that said it's already unconstitutional. So you can't have relief in New York or Massachusetts or Colorado with another court and let them battle it out. No, if you're not happy, you come right back to the same court that said this board is unconstitutional. It's a problem that needs to be addressed, and I think that the bill before us goes right to that, to bring certainty back to the board, because I agree with my friend and with everybody who has spoken that we need a functioning board that we can all recognize is constitutional and has the power to make decisions.
I'll just very briefly say that my chairman's reading of the statute is obviously correct, that the general counsel does have certain interim appointment authority. We don't have a general counsel. We have an acting general counsel.
Yes, we do.
Because that nominee wasn't voted on by the Senate either. So there is some legal ambiguity here. It's clear that a general counsel who's confirmed can do what you just said, but Mr. Solomon is not general counsel. He is acting general counsel, because just as with all the other nominees, he's never been put for a vote before the Senate.
If I may, that it's true, absolutely, that he is the acting general counsel, and there is some perhaps legal ambiguity there, but my argument is that without a board, it's almost irrelevant. We need to get a functioning board.
I agree with you.
And there's no other way to turn except to make it clear that any more decisions, they're not allowed to make more decisions. Their previous decisions have to be reviewed by a constitutionally constituted board, and we need the president, with all due respect, and the Senate to work together to resolve this. I yield back.
It's a mess. Mr. Nugent. I always love it when we have the Senate to kick around. We wouldn't have this discussion today, and I think we all agree, if the Senate was doing their job.
Right.
But that being said, and I appreciate Mr. Andrews, obviously your legal background, scholar, and maybe you could help this old cop out a little bit. But when the D.C. court took this up, obviously they have the competent jurisdiction over this because of why?
The Congress, when we created the National Labor Relations Act, gave exclusive jurisdiction to appeals to the D.C. Circuit. So by statute, they were given exclusive jurisdiction of appeals.
Now, back in my law enforcement days, if the jurisdiction, the circuit that the jurisdiction was, whether it was the 11th Circuit or whatever the jurisdiction was of the federal courts, that had jurisdiction over the areas in particular, just that area. We didn't have to worry about it, you know, if it was over in Southern California District Court, it didn't really apply to a Florida District Court or state courts only because the Supreme Court hasn't yet ruled. But in this case, the District Court is, until the Supreme Court decides to take it up or not, is the competent jurisdiction, correct?
It's the only appellate court before the Supreme Court, that's right.
So if nothing happens, let's say the chairman didn't bring this bill forward, and this body continues to make decisions that they're making today, what jeopardy does it put all those decisions if, in fact, the D.C. Court's decision is upheld? What happens after this point, all these cases that may be heard from today forward? Does it put those cases in jeopardy?
Well, when Mr. Nugent says nothing happened, do you mean that the U.S. Supreme Court doesn't hear the case? Or what do you mean?
The U.S. Supreme Court does not hear the case. Or hears the case and agrees with the district court. Worst case is, either way, anything that happens from this point forward is also in jeopardy. Is that correct?
That would be correct, yes.
Knowing full well that the competent court of jurisdiction has already made a decision that they believe that it's unconstitutional what the president did, thus those appointments are unconstitutional.
Now, I would say this, Mr. Nugent, though, if I may, that my belief is that the D.C. Circuit could have enjoined the board from making any future decisions, and it did not do so.
Well, from strictly a law enforcement standpoint, when the district court, federal district court, makes a decision like that, typically what happens is we stop that activity because we don't want to jeopardize future cases. It's just common sense. You stop that activity because you don't want to jeopardize a case. It may be a legitimate case, but because that court has ruled it, why would we go ahead and continue down the same path? And so my question is, if we ignore this and we allow this to continue on, are we not? And I was a vice president of a union when I was in Chicago, so I'm not anti-labor. I worked with, actually, my folks first unionized under me as sheriff. So I'm not anti-labor, but it certainly puts them at extreme risk when they don't have the ability, because of an unconstitutional, constituted board makes decisions where they think, geez, we just won, and in fact they may have just lost.
I would only say to you that the members of the board, acting in good faith, have the right to, the prerogative to assume that they have the authority to do this, pending the appeal to the Supreme Court. Now, you can quarrel with whether their judgment is right or wrong, and you frankly can pass this bill to stop them from doing it. But the D.C. Circuit, to my knowledge, also had the authority to deprive them of that discretion and did not do so. So they left it in the good faith judgment of the remaining members of the board.
But the same holds true, though, with the interim appointment of the general counsel, correct? He has the same latitude in regards to, you talked about the districts in regards to decisions making in districts?
Yes, I assume he could make that same choice, yes.
Okay. With that, I do appreciate
Yes.
your testimony, and I appreciate the chairman and moving this forward. Thank you very much.
Thank you very much. Mr. Webster. Dr. Burgess. The gentleman says not seek time. Thank you very much. I want to thank both of you for taking time to be here. As you know, this committee does not vote on our favorite witnesses, but we have on a regular basis an activity with you, and we count on both of you not only coming up and giving your best advice, but the spirit in which you approach this committee. This committee has an important part of the process. The outstanding members that represent not just Mrs. Pelosi, but also Speaker Boehner are on this committee, and both of you are welcome in this committee, and I appreciate your spirit, the fire, and the advice that you give this.
I think if you ever did vote on favorite witnesses, we would like to be considered.
Well,
I'd like to second your
we've
statement.
already helped Mr. Andrews in his legal career today, and he was the one that would argue that he did not live up to that. But the spirit of this committee is here for many, many long hours, and sometimes it's fun and sometimes it's a beating. But I must suggest to you, we're trying to be open for business. We're trying to take the content that comes from professionals just like both of you, and I think that we were you did well today, and I appreciate both of you being here. So both of you are now excused, and the chair does not see at this time any further member wishing to give testimony, and so the hearing portion of this bill is now closed. H.R. 1120 is now closed, and the chairman would be in receipt of a motion from the gentleman from Utah.
Mr. Chairman. Okay. Now I move the committee grant H.R. 1120, the Preventing Greater Uncertainty in Labor and Management Relations Act, a closed rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Workforce. The rule waives all points of order against the consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of the Rules Committee Print 113-6 shall be considered as adopted. The bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. And finally, the rule provides one motion to recommit with or without instructions.
The gentleman from Utah has placed a motion before the committee. I'd like to take just a minute, if I can, and to explain the rule. Obviously, this is a closed rule. It provides for 1 hour of debate controlled by the Committee on Education and the Workforce. It provides one motion to recommit with or without instructions. The facts of the case that have been presented today is that we had 2 amendments that were submitted to the Rules Committee, one a Democrat amendment and one a Republican amendment. Both amendments were subject to a point of order, and it was the hope of our committee staff, the professional staff, and I believe on both sides, Republican and Democrats, to try and work with those that would choose to not be subject to a point of order and to make them germane and prepared. That did not happen. So the committee solicited amendments, but no member was able to follow that germane amendment rule. And so this is where we are today. So is there further amendments or discussion on the gentleman's motion? Those in favor, seeing none, the vote now be in favor of the motion from the gentleman from Utah. Those for signify by saying aye. Those against? No. The gentlewoman would request a roll call. Clerk would offer.
Ms. Fox. Mr. Bishop. Yes. Mr. Bishop. Aye. Mr. Cole. Mr. Cole. Aye. Mr. Woodall. Mr. Woodall. Aye. Mr. Nugent. Mr. Nugent. Aye. Mr. Webster. Mr. Webster. Aye. Ms. Ross-Leitman. Mr. Burgess. Mr. Burgess. Aye. Ms. Slaughter. Ms. Slaughter. No. Mr. McGovern. Mr. McGovern. No. Mr. Hastings. Mr. Polis. No. Mr. Polis. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk will report.
7 ayes and 3 noes.
The motion is agreed to by the gentleman from Utah. And so we will now move to naming the manager, which will be Virginia Fox on behalf of Republicans, and Mr. Polis for the minority. We do not anticipate further meetings this week. I want to thank all the members of the committee for taking time to be here and for effectively getting through this work. And I appreciate the time that everyone has spent. The committee is now in recess. Adjourned.